So far as the commercial side of the coin has been considered, what could we say in relation to private trusts? Is Malta a likely jurisdiction for what we could call family estate planning?
Basically, in the Maltese legal context, we have a situation where trusts are available alongside other institutes. We have institutes which are typical of civil law countries, and trusts have been added, they've given added value to this already legal system which is robust in its contents. From a planning perspective, trusts could basically be set up in two ways. We have the inter vivos option, which is basically trusts being set up during the lifetime of the settler, and also there is the causa mortis option, whereby the trust is viewed as an instrument offering benefits to operate, however, on the contingency of the demise of the settler. It is also important to say that we can combine both options, so we could have a trust which commences during the lifetime of the settler, continuing causa mortis. Now, why would one offer and opt to go for a trust in this context? Basically, the trust caters and provides added value in particular situations. So I would need to consider the particular conditions of the settler and of his family context. So, for example, having a beneficiary who has a disability, or if the settler would like to make sure that the education and maintenance requirements of the beneficiaries are catered for throughout the years. These are only two typical examples of where the trust option would be attractive, but these offer an idea why we'd go for a trust. In these situations, would suggest a trust to a client, and obviously we'd set up the trust to tailor-make it so it would be malleable enough, it's malleable enough as an instrument to cater for the particular needs. One must also mention the option of trust in the family office option, which basically sees for the added value which the instrument of trust could add being interposed with other instruments, and obviously this leads to the doing away with the problems which arise in such contexts, typically arising from the co-ownership, which is normally vested in plural family members, as opposed to the streamlined option which a trust would offer in these cases. So in family office setting up, the trust is clearly another way, another tool which offers added value. In the private trust sphere, we also encounter many a times the trustee being a family member, so basically it is someone who would be related to the settler and within the degrees laid out by law, and basically there would be also the interposition of the notarization requirements, so we're allowing the trustee to be a family member, we are giving a more enhanced role to a notary, which gives the certainty and also fills in for other requirements which are generally supplemented by the licensing requirements in professional trustee scenarios. And also our law tries to give the added certainty to the settler by the interposition of people like the qualified person, which basically give a regulation to a private trust scenario which is meant to operate as an informal instrument within a family context. Basically, in the private trust scenario, we see a system which offers malleability on the one hand, so basically we want to cater for the needs of the clients, coupled with legal safeguards to ensure the fulfillment of the fiduciary obligations by the trustee.
Italo, if I may come back to you, we've spoken about trusts operating in the commercial and in the private spheres. The trustee is clearly the crucial player in this trust. Who can act as a trustee in terms of Maltese law?
Maltese law does in fact regulate the office of trustee in quite a bit of detail. We find principally two types of trustees. You have the professional trustee, who would basically be required to obtain a license from the Malta Financial Services Authority, thus securing certain certainty on the adaptability of the person applying for such license. And there is then also a possibility of having a private trustee. Now, in case of private trustees, the law provides for a situation wherein this office could be held either by a person who is who cannot hold out himself to be a trustee per se, but acts as such for people who is close to by way of knowing the person for a certain period of time, or as by being a family member. In fact, private trustees can act as such if they are related to the settler either by consanguinity or affinity up to the 4th degree, or else have known the settler for at least 10 years. In both cases, however, the trustee is bound by fiduciary obligations towards the beneficiaries, being the ultimate beneficiaries of the trust itself. It is also important to point out that in the case of the private trustee, the notarization formalities as prescribed by law would be applicable.
Annalise, I come now to tax. From a tax perspective, would it be correct to state that trusts are tax-neutral instruments as far as Malta is concerned?
Having a Maltese resident trustee is essentially the connecting factor which establishes jurisdiction for the trust to have the income taxed in Malta. In line with the typical and the normal rules governing taxation in Maltese law, if the beneficiaries are neither resident nor domiciled in Malta and the income does not arise in Malta, we have a situation where there is no taxation implications in Malta. But at the outset, it is important to specify that the trust in itself is not viewed as an instrument to minimize taxation incidents. There is the principle of transparency, which is crucial to the understanding of the taxation implications in Malta. So basically, from a taxation point of view, having regard to the nature of the trust, the nature of the assets in the trust, the source of income, and also the status of beneficiary, the idea of the Maltese legislator was to set up a scenario, obviously legislatively regulated, whereby the trust is looked through as though there is no interposition of the trust. So the transparency principle offers this look-through the trust, removing the facade which the trustee is placed by his interposition, and for taxation we look through the structure. What I am saying is based on the domicile and residence rule. So we are supposing that the beneficiaries are resident, ordinary resident, or domiciled in Malta. During the lifetime of the trust, one can mention several taxable incidents, or several moments which give rise to taxation. We could mention the settlement of property on trusts, the administration of the trust itself, the distribution of the trust assets at the end of the termination of the trust, also the reversion of the trust property back to the settler, and the transfer itself of the beneficial interest. So these are all moments during the lifetime of the trust which could possibly give rise to a taxation incidents. But coupled with this, to get a clear view of how trusts are operated from a taxation perspective, we have to bear in mind that there are a number of exemptions which are legislatively enacted whereby there are tax-free incidents. So for example, having regard to the relationship operative between the settler and the beneficiaries, or the trustee once there is the distribution of the trust assets, so bearing in mind the relationship, there would be a non-taxable incidence in view of this relation. So the trust in itself is taxed in the same way as another gratuitous disposition, so a donation from a civil law perspective without the operation of the trust would be taxed. So to make it simple, if from a simple donation perspective we are looking at a situation where, looking at the donor and the donee and the relation between them, there would be no capital gains, for example, by having the same situation analogously applied to the trust scenario, so the settler and the beneficiary are related within the same degrees of relationship, this would give rise to a non-taxable incidence. So basically the idea was to have a situation where having the trust does not put the parties in a worse off situation than they would be if the trust would not be interposed. So in line with Maltese law on trusts, there is a vast array of assets which can be placed in trusts. But is everything taxed? No.
I think that brings our conversation to a conclusion. Could I thank you very much for, certainly for myself, making the picture about trusts in Malta very much clearer, and I certainly found it hugely useful. Thank you.